Good morning and welcome to All Things Marcellus with me, Attorney Doug Clark of the Clark Law Firm. I am located at 1563 Main Street in Peckville, Pennsylvania, and I am right here with you each and every week at this time on this station to bring you, the landowner, the information that you need regarding natural gas development here in Pennsylvania. At the Clark Law Firm, my focus is on land owner, property owner, oil and gas right owner representation. In case you don't know this, I have not, I will not, and I do not. I have not, do not, and will not represent gas or pipeline companies. Never have, never, ever will. I represent landowners, property owners, and gas right owners for such things as gas lease reviews, negotiations, pipeline reviews, negotiations, royalty deduction issues, unitization issues, breach of gas leases, breaking the promises of pipeline agreements, estate planning issues, estate planning with natural gas clients, surface use agreements, roads, you name it, any and all matters relating to oil and gas rights, buying and selling oil and gas rights. Guys, if you're going to enter into an agreement to sell your gas rights, you need to talk to an attorney first, because if you're signing certain documents, like a sales agreement, like these realtor forms, you can run into problems. I don't say that because it's anything but true. You can run into problems. So please, before you sign a document to sell your property or to sell your gas rights, you better darn well be speaking to somebody who knows what they're doing. And I would say, no offense, realtors, but it should be an attorney who deals with oil and gas issues, so you are protecting yourself and making sure that that transaction is completed in the way that you want it completed, and that at the end result is exactly what you anticipated to be and planned the end result to be. You have to be careful about this. I've twice in the last couple weeks have seen people already sign sales agreements and they come back to create issues. Get advice, consult with me or somebody who knows what they're doing before you sign anything. You know, in that note too, this is a good time to say it. I'm going to get commercial for just a couple minutes here, but it's true. It's really, really true. Stop anybody out there who is presented with an agreement or will be in the future, but presented now. Stop signing these agreements when they are presented to you and you are not getting assistance, advice. You're not doing a review and consultation. You're not understanding fully what you are signing. The document, you may be able to read and understand everything that's in the document. Maybe you can. Most times there's legalese and there's phrases in there and there's words that are very difficult to understand or have certain terms of art meaning within the industry. But let's just say you understand everything in the document. You read it, it all makes sense. But that doesn't mean that there may be, as this document kicks into operation, consequences that you never thought about or that you never understood because you're not involved in oil and gas exploration development, because you're not studying the evolution of case law in Pennsylvania and other jurisdictions as to how this agreement may negatively affect you in the future. No, you're signing because a friendly landman said, oh yeah, this is good. We're going to make you rich, get you money, hurry up here, sign here, sign here. I also said those words, hurry up, hurry up. Here's the other advice to you. Stop hurrying up. Why do you need to hurry? Look around. Think about whenever people sign documents in the past. It's always hurry, 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 hurry. Even if it's hurry up and sign and then give us 5 years to decide whether we're even going to use this agreement. But now we're in a big hurry because, my opinion, they don't want you to get advice. They don't want you to talk to an attorney who knows what they are doing. They don't want you to know information that you should have in order to make the best decision for your situation. And ladies and gentlemen, I have landmen call me to represent them on their own personal matters related to oil and gas. If that doesn't tell you something, if that does not tell you something, I don't know what will. If the fact that thousands of people sign for $25, $50, $100, 12.5% full deductions, and we're told, hey, it's never going to get any better than this. This is a miracle. This is wonderful. Free money. You should take it. If we don't learn from those mistakes, if we don't learn from decade plus of bad agreements, then I guess, I'm not going to get discouraged. We're going to learn. Let's learn from them. Let's learn from these things. You're listening to Attorney Doug Clark. This is All Things Marcellus. Make sure you join me each and every week at this time on this station. I'm going to talk some about royalties. I want to talk about arbitration. I want to talk about how companies how companies use the language in the lease to deter or prevent people from ever suing them. But I want to stay on this for a minute. Again, because I am seeing it now so much, and it's always happening, but I'm seeing it more and more because, look, there was a slowdown in drilling. Natural gas prices, series of events occurred where lack of pipeline capacity, where there's been less drilling than what the companies may have even planned. As a result of that, companies may have actually lost their lease. They may have lost the lease because they didn't conduct certain operations in a certain time frame. So, hey, that sounds great. Good news. And generally, that is good news, generally for the landowner. However, companies will then go out to that landowner whose lease may have already expired. Again, whose lease may have expired, but the landowner doesn't realize that because it's complicated. It's detailed. The landowner isn't familiar with the shut-in law, the production requirements, with all of the different language within the lease, the ancillary rights. No. So they don't know that their lease terminated or may have actually terminated. So when the landman comes out or the company representative comes out and says, hey, we want you to sign this amendment, modification, and then the big R word, ratification. Here's the document. Oh, and by the way, this is so good for you because once you sign, hey, we're going to get this thing cranking. We're going to get you royalties and you're going to be living in Beverly Hills and you're going to be a clampet. And I find that very degrading as a kid who grew up in Armstrong County on the airport road. Don't say that to me. Don't say that to me. So anyway, sorry, that just gets me very upset. So anyway, I'm not going to sit there. It's like the classic thing. Here, look at this shiny object here. We're going to make you rich. We're going to make you rich. Don't pay attention to all of these words on this paper that may have a serious detrimental impact as far as not being able to obtain additional money now and even into the future. So let me go back. You have a lease that, let's say it expired, or it probably did, because sometimes it's not super clear. So a company, in a case where the lease may have expired, or maybe where, it looks like it could have expired, but maybe it didn't, there's argument on both sides, that can give you as a landowner tremendous leverage, because a company with a lease that is expired, obviously they would need to have a new lease unless you sign an amendment modification that revives it or brings it back to life that you didn't even realize that that's what you were doing. Or maybe they think the lease may have terminated, which they don't want to go ahead and conduct operations or drill under this property or develop it. They do want to, but because the lease may have expired, well, they don't want to go ahead and develop this under this existing lease, which may or may not have expired. So what do? Knock, knock, knock. Hey, landowner, here we are, opportunity knocking. We'd like you to sign this amendment, modification, and maybe even throw in the word ratification. And we're going to do this, and maybe what they do too is throw in some terms or some language in there that they think that is going to be attractive to you, such as, oh, we'll test your water. Here's a water testing provision. Oh, here's another provision how we'll follow the laws. Well, look, they're going to test the water anyway. They should follow the law anyway. They're going to give you potentially some throwaway provisions, but then sneak in a provision that has a lot of value to them, and you don't even understand it. You don't realize it, but you're told, hey, we need to get this done. We're going to get your royalties. We're going to start drilling. You're going to be rich. Everyone's going to be rich. So you sign. Stop signing. Stop signing these agreements. And not just amendments, modifications, and ratifications. Stop signing releases. Hey, Tioga County landowners, if you have a vertical pad, if you have a vertical pad or a vertical well and a pad on your property, and SWEPI, Shell, comes out to you with a release, my general advice, call me, do a review and consultation, and get specific advice. Again, if you are giving a release for a well pad that's been constructed and SWEPI or Shell gives you a release now, call, learn about reviews and consultations, 570-307-0702. 570-307-0702. Here's what's happening. Here is what is happening, not just in Tioga, not just in southwestern Pennsylvania, but it's been happening across Pennsylvania in gas-producing areas. What is happening? My opinion, my very strong opinion. What occurs is some of these leases have expired or may have expired. And in order to avoid any potential claim by the landowner and to fix or revive an expired lease or a lease that there's a question about, they will come to you with an amendment, modification, ratification. Now listen, they can take the forms of amendments, they can be modification of the lease or ratification. Be careful. Do not just sign those agreements. If you get one thing from this show today, do not sign amendments, ratifications, and modifications without getting specific legal advice. I do these reviews all the time. We find more than you would think. Not every time, but it happens where these amendments, ratifications, modifications are used as a tool by the company to fix, to revive terminated leases and to fix extremely fatal issues with the lease that the company couldn't otherwise identify or develop. So then what happens is, if you're able to identify that, you may be in a situation where you have no lease and now you enter into a new lease. Let's say you have 100 acres and you can get $1,500, which some places we get much more. Some places a little less. You get $1,500, 100 acres. That's $150,000 that you got. You do a review and consultation, as an example. It takes an hour or two. If there's no issues and everything is okay, then you're told that. And then you go ahead and you can sign that document if it's in your best interest. But you might find that your lease has probably terminated. I may say, look, I think strongly it's terminated. Or, hey, look, it may not have terminated, but boy, it may have. And this is a real gray area. And it's one where the company probably is not going to want to take the risk and would probably offer you money to sign this document, maybe even a new lease, but they don't want to develop it in the way it is. So that's why they're coming and giving you an amendment, modification, or a ratification. Please watch out for those documents. Get help. Get assistance. If you don't call me, call someone that knows what they're doing. You're listening to All Things Marcellus with me, Attorney Doug Clark of the Clark Law Firm. I'm here each and every week at this time on this station. Give us a call. Learn about what we do. Also, check out the websites, pagasleaseattorney.com, pipelineattorney.com. I've been doing this radio show, All Things Marcellus, since 2010. You can go to the websites, listen to prior shows. all types of different topics. We mix it up, try to talk about hot topics each and every week. And this week, it's just, I'm going out of my mind with these these modifications, these amendments to leases, and these ratifications of leases. The one I read the other day, it says, you agree, landowner, when you ratify this lease, that there's been no breaches of the agreement. You also agree that these new terms are incorporated into the agreement. The company just fixed a lease that almost certainly terminated if you sign. And by signing, you could be losing hundreds of thousands of dollars in bonus money. You could be losing an opportunity to increase your royalty percentage. You can be losing these things. This is true. Now, it is possible that the amendment and ratification, modification is something that may be in your interest to sign as presented. Many times it's not, but it may be. And that's the benefit of a review and consultation, is we identify, why are you given this? What does this mean? And is there leverage there? Is your lease still valid? Has it maybe terminated? What can you do about this? If you are signing amendments, modifications, ratifications, the gas leases, pipeline agreements, or any other document, and you're not getting assistance, what are you doing? You're listening to the landman and the company representative telling you what this document means to you and how it's going to work for you into the future, and you're not getting information that probably you should have, in my opinion. And that's what we want to do. Get you the information. If it's in your best interest, let's do it. If it's not in your best interest, let's talk about what is. You're listening to All Things Marcellus with me, Attorney Doug Clark of the Clark Law Firm. I'm here each and every week at this time on this station. We're going to keep doing it. I'll be right back after this break. Welcome back to All Things Marcellus with me, Attorney Doug Clark of the Clark Law Firm. Give us a call. Learn about reviews and consultations. Learn about any other type of representation, royalty deduction issues, unitization, and man, I want to scream this, amendments, modifications, ratifications, selling gas rights. Call us. Call me, the Clark Law Firm, 570-307-0702. 570-307-0702. I try not to make the shows too commercial, but I want to say again, we need to stop signing these documents blindly. We need to stop relying on the landman who works for the company to give us the information that we need to know to make the best decisions for us, for our property, and for our children and future generations. I'm going to say this. I promise you, when I see a client, I see my grandfather, my grandmother, my parents, the neighbors that I grew up with on Airport Road in Armstrong County. That's what I see. And I see an opportunity, not an opportunity to make money, but an opportunity to help somebody, to help someone to make sure that whatever they do, it's in their best interest. That whatever they do, they understand the good and the bad about what they're going to do, so they can make the best decision in their best interest. I don't sit here saying, oh, how can I generate work? Never done that. Never done that in my entire life. Even when I was young and starting out and didn't have a lot of work. No, it's about what's right. It's about what is right. And we, on our side, the people that have lived in Pennsylvania our whole lives, the people that have worked the farms, the people that love these properties, we need to make sure that we have the information to make sure that we maximize. You hear me say that all the time, and I believe it so much. We need to maximize each and every situation and opportunity, because I assure you the company is doing that. And I also want to say, regardless of what your thought may be of lawyers or any other experience in lawyers, I would just say, and I don't want this to come up, but give us a call. Learn about what we do. Go to the websites. Read about what I do. Read the testimonials that are from real clients. Get that information and find out if we're right for you. Because for most people, I think we are. Because I know where we're coming from, I know what we do, and I know what our goal is, and I know what we've done in the past and how it's worked. So I want to hear from you guys so we can help you in any way. And if I can't help you, or if you call and you don't like what you hear, then hey, you spend a phone call. But let's get you familiar with what we do, what we can offer you, what I can offer you, and regardless of where you are in Pennsylvania. Did a couple of reviews and consultations in Fayette County, Washington County, I think just on Thursday of this week. Greene County, Butler County. I'm from, like I said, Armstrong County. Have so many clients and have represented so many people in Tioga, and all across the northern part. So regardless of where you are, as long as that property is in Pennsylvania, your issue is a Pennsylvania issue, give us a call. See what we do. 570-307-0702. I promise you, my goal is to help each and every person to the best of my ability. And I feel sometimes that people are afraid to call, or, hey, I don't want to call a lawyer, or, oh, this is going to cost so much money. I do these reviews and consultations, usually 1 to 2 hours typically. And sometimes if it's something easy and it's a no-brainer, hey, yeah, this is okay, it doesn't even take an hour. But you got to have it reviewed and looked at. Or you can just sign like many, many people do. And sometimes the good news is they don't realize that they might have missed out on hundreds of thousands or tens of thousands or whatever the amount of money may be. But they don't realize. And I can't tell you, I'm going to let this go here in a second, but I can't tell you how many times I talk to people. People call and I'm doing a review and consultation for a pipeline agreement that they have offered. And then maybe it turns into a negotiation, maybe it doesn't. But as part of that process, they send me their gas lease because I have to identify what rights there are in the gas lease to install pipelines. Quick side note, many times the company represents that I've seen, the landman, oh, we have the right to do this, when no, they need your permission. That's a quick side point, but a good side point to remember. So, okay, landowner sends me their gas lease. We're going to do a pipeline review and consultation. They send me the pipeline agreement. They send me the gas lease, looking it over, and I think, oh, my heavens. And I just, again, this gives you an idea how often this happens. Just the other day, I was reviewing a multi-unit well consent for somebody in Susquehanna County from Cabot. And I'm going through the gas lease, and I see when they signed the gas lease, it was around the end of 2008. And I'm very, very familiar with this area, the time frames, what the market was in 2008. And these guys with a big piece of property, very large piece of property, did not get a royalty without deduction addendum added to their agreement. It could have been as easy as saying, hey, can I have no deductions? And it would have been given to this person at that time. Everybody got royalty without deduction in this area at that time if they knew to ask for it. And these people lived in New Jersey, and they weren't real familiar with everything. So what ended up happening? Well, they signed a gas lease for their very large piece of property that allows for deductions. When had they called and said, hey, we have this gas lease, can you review it, talk to me about it, I would have said, look, don't sign this. I'm so glad you called, because very easily you can have an addendum term that will eliminate deductions in the future, which in your case will probably increase the value conservatively of this lease by hundreds and hundreds of thousands of dollars. And that would have occurred had the people called. Now, maybe they didn't know, whatever the reason, but they didn't call and they didn't get that information. Instead, they relied, shockingly, on the company landman and said, hey, sign here, we'll make you rich, we're going to get you money, this is wonderful, here you go, sign here, sign here. The landman, by the way, didn't say, oh, you know what, also, if you ask me, you can get royalty without deductions. Also, yeah, you know what, I can give you royalty without deductions, let me give you that too. No, it didn't occur because they didn't get royalties without deduction. Those things still happen. Now, they still happen now, and we got to stop it. You're listening to All Things Marcellus with me, Attorney Doug Clark of the Clark Law Firm. You can join me each and every week at this time for All Things Marcellus. You can call the office, get at least a review and consultation if you have any oil and gas related issues. Stop signing these documents without having a review and consultation with a lawyer who knows what they're doing. You can call my office, 570-307-0702, or call someone else who knows what they are doing. But call someone. Stop relying on the company to tell you what you should know. Think about that. Rely on the company to tell you what you should know. You're listening to All Things Marcellus with me, Attorney Doug Clark of the Clark Law Firm. I'm going to cut this one short. I'm going to talk about royalties. I'm talking about the old double whammy, the royalty arbitration combo. Royalty arbitration combo. I call it the double whammy. I'll be right back to explain it. And remember, right here at this time, each and every week on this station, you can call the firm, 570-307-0702. I'll be right back. Welcome back to All Things Marcellus with me, Attorney Doug Clark of the Clark Law Firm. Remember, join me each and every week at this time on this station for All Things Marcellus. I've been doing the show since 2010. If you're new to the show, or if you've not gone to the websites, go to pagasleaseattorney.com, check it out. Go to pipelineattorney.com and check it out. We have the prior radio shows for the last couple years or so up and available on the websites. Go check them out. And think about pipelines, pipelineattorney.com. Whether you're interested for representation or information, use the websites as a resource. Use the radio show as a resource. Even if you're not looking for representation, take it as an opportunity, as a general resource. It's not specific advice, the show or the websites or anyone, but it's a resource. Think about things. Get you thinking. I know we get I can see the traffic to the websites, and it's encouraging because we want to get that information out there. We want everybody to do better. Not just my clients. I want everybody to do better. So let's take advantage of these resources and become educated and informed, because that's the power for us. The companies don't want you to be educated and informed on these subjects. Why would they? Well, they don't. All right. I'm going to talk about now the combination. I use the term double whammy. You know, it's not like it's funny when as a kid. I remember there used to be a game show like Big Bucks, No Whammies. Come on, stop. I must have watched that a lot, I guess, and sitting in the living room again on the airport road. But anyway, I call it the double whammy, but it's not, to me, it's kind of a funny name, but it's not a funny situation. So please don't take it that way. Here's what I mean. Companies put royalty language in their leases. That should not be a surprise to anybody, is beneficial to the company. You as the landowner, as the oil and gas right owner, must try to improve that language. Some cases, we can improve that language 100%. Some cases, we can improve it some, but we can't make it ideal. In some cases, we can't even improve it. But we have to try, and then we have to understand in those cases where we cannot improve it, what the negative is, and then make a decision. Hey, do I want to go ahead and enter into this agreement at this time, knowing exactly how my royalties will be calculated and paid? So you're informed. And that's the thing that, I can't state enough. Those reviews and consultations, the worst thing that happens, generally 1 to 2 hours, and you're informed. And if you go ahead and sign, you know what you're signing. And you know, okay, now I understand it. I see the pros, I see the cons. But if you're just signing, I guess in some ways, if you got totally taken, you won't know that you did, because you wouldn't know what was available. So we got to stop that. We have to stop that. You're listening to All Things Marcellus with me, Attorney Doug Clark of the Clark Law Firm. right here with you each and every week at this time on this station. You can call the office anytime and call before you sign 570-307-0702. Again, amendments, modifications, and ratifications. But anything else, but we're highlighting amendments, modifications, and ratifications some today. Don't just sign those documents. Get them reviewed. Get them reviewed. They may be a tremendous opportunity for you. Do not miss tremendous opportunities. Let's not miss them. And we can identify those generally in an hour or two of time, which includes a conference call or an in-office visit to explain everything. 570-307-0702, regardless of your location. Call, see what we can offer, and see if that's good for you, if that works for you. So, okay. Talking about the double whammy of a poor royalty provision. A royalty provision that benefits the company is the first part of the whammy. The second being a mandatory arbitration provision. These are designed, in my opinion, and I think very strongly this way, and I think that you put some people on a lie detector test, and I think you'll find that I may be right here. But this is designed. These arbitration provisions are designed to deter or even prevent lawsuits, though they're presented to you in a way of, oh, this is great. It's much quicker. It's cheaper. Here's what you say back. Well, good. Since it's so good for me and it's cheaper and you're doing this all for me, you as a company will not mind getting rid of it then. Thank you so much for offering me this arbitration provision that's so good for me. Thank you. But I'm going to pass. So I don't want to have it. So you can take it out since it's in there for me. See what they say. See what they do. All of a sudden, I'm not sure if they're going to do that. They don't like to take it out of their forms. Well, of course, they don't want to get rid of arbitration. Listen, each and every person who is not currently leased or has a lease offer, my general advice, seek to get rid of the arbitration language and see what the company says, which will tell you that, hey, if they don't want to get rid of it and they tell you before it's a benefit to you, well, surprisingly, maybe they were lying. Maybe they were misleading you. So think about that. If something's good for you and you say, hey, well, you know what? I know it's good for me, but for whatever reason, I still don't want it. See if they get rid of it. That's very important. So, okay, let me talk about this now. So, all right, here's the royalties part. And I'm going to tell you, I have multiple leases sitting here in front of me. Getting ready for the show, I pulled some leases. And this is the truth, too. I pulled them randomly. I just pulled some random leases that I'd worked on recently to say, okay, let me look at some of this arbitration language. Let me look at some of this royalty language. So I have several samples. But I have one which is probably more extreme than the others. So that's what I'm going to look at. You're listening to All Things Marcellus with me, Attorney Doug Clark of the Clark Law Firm. So, okay. This royalty language, comes from the royalty section of this lease. So, okay, here goes the royalty section. I'm going to paraphrase a bit. It says, on gas, talking about the royalty, saying that the landowner is going to receive a certain percentage, let's say 15% of the market value at the well for gas. Goes on and says, now this is verbatim, market value at the well will be determined based on either the company's sales proceeds, which include sales to affiliates of the company, or a published index price, less landowners' pro rata share of post-production cost. So they're saying we're going to give you 15% royalty based upon we as a company, what we obtain when we either sell it to an affiliated company that we own, or we use a published index price. It doesn't say where that index price is going to be calculated at. It just says published index price. Does that mean they can use any price in the country? Or does that mean they'll use a local price, which is going to be one of the lower prices in the country due to the fact that we have a large amount of supply of gas and we have pipeline infrastructure issues trying to get the gas out to distant markets? But the bigger point is that the company has the ability to calculate your royalties in one of two ways. One being setting the price of your gas at the price that the company sells it to itself at. They own the affiliated company that, say, is a marketing company that's going to buy the gas from the gas company. And then that second affiliated company goes out and sells the gas to an actual third party that has no relationship with the producing company or the affiliated company that goes out to sell the gas. Now, that's one way to calculate the royalty. Well, that makes us nervous because imagine this scenario. Say the producing company, the gas company that you're familiar with, owns that affiliated company in whole. And when they do, then any profits generated by that company that they own ultimately comes back to the actual gas company. So, if they pay the affiliated company less than what the actual market value is, they may then be able to pay you less royalty, but at the end of the day, because they own the affiliated company, they still make all of the money and even more, because instead of paying you royalty based upon the price that the gas was actually sold at to a third party that the company had no relationship with or ownership relationship, they set your gas price based upon the price that their affiliated company and the company producing your gas, what they've agreed to as the sell price. So they can be 100% related and reach an agreement as to what the value of your gas is. That is not a good situation for the landowner. Now, that's my hypothetical situation, not a good situation. We want your gas price to be determined on the open market by two companies that have no connection or business or ownership relationship. We want a fair market transaction. We don't want your gas to come out of the ground and the company who is developing your property that you have your lease with that pays you royalties, they then sell that gas at the wellhead the second it comes out of the ground to a company that they own, and they set the price, and that's how your royalty is calculated. That, ladies and gentlemen, is not a good deal for you. So this lease says they can do that. It also says that they have the option to use an index price. That doesn't say where the index is going to be. It doesn't say that you have to get the greater of the index price or the gas price that these two companies who are affiliated set between themselves. It says that they have the option to give you one or the other. Horrible language for a landowner, in my opinion, and I don't think anyone's really going to contest that. It's not good language. Even if it said the greater of the two, the affiliated sell price or the index price, it would be better. But I assure you, it is nowhere near what we want, and it's what I rail about all the time. Affiliated sales and index pricing, we need to be careful. We need to understand it, and we need to protect ourselves. But this is worse. This says company, they have the choice. I can use index sales, or I can use, or the index sell price, or I can use my price that I sell it to myself at. Clearly, not a good provision. So we need to try to improve that. And if we can't, for some reason, improve it, We need to understand our situation and decide, okay, is this the right time? Is this the best move for me? Maybe it is, maybe it isn't. But we need to address it and we need to understand it. Not just simply sign because we're told we're going to be rich. So that's the first one. That's our first whammy. The company can sell it to themselves and set the gas price and pay you royalty on the price that they set in the self-dealing affiliated sale transaction. Or they can use an index price. We don't know where. We don't know what index price, but they can use an index price. Do you think they're going to give you the higher of those two options? I don't think so. I don't think so. All right, that's whammy one. We're going to talk about how arbitration clauses, mandatory arbitration, make this type of royalty language and so many other provisions that are similar extremely difficult, if not impossible, from a practical standpoint to challenge. Stay with me. I'm going to explain it. We'll be right back after this break. But remember, tune in each and every week at this time on this station with me, Attorney Doug Clark, for all things Marcellus. I will be back after this break. You can always call us 570-307-0702. Welcome back to All Things Marcellus with me, Attorney Doug Clark of the Clark Law Firm. I'm going to jump right into it here. Got a lot to cover in this last section, but remember, join me each and every week at this time on this station, and you can contact the office 570-307-0702 regarding representation, or you want to learn more about representation. Okay, let's get into it here. So, second part of the whammy. Whammy number one, company gives you a royalty provision that is beneficial to them. Or company gives you a royalty provision that they interpret to allow deductions, but you didn't think it would. And maybe even the heading on your lease says royalty without deductions. Maybe it says that in the addendum, but then you find that you have deductions being taken. So you say, okay, well, I'm going to sue the company because they're not allowed to do what they're trying to do, and I'm going to go ahead and sue them. Or maybe you have a market enhancement clause, you have a ready for seller use clause, and the company says, hey, we interpret this clause in your addendum to allow for deductions. Well, if you can't get them to change their mind, which they've obviously made a decision, they're not going to change their mind voluntarily, you're going to have to sue them if you want something to change. One of the tools available to small land owners, and even when I say small, it can get pretty big in the size of the property, is to proceed against the company as a class or as a group. And the companies don't like that because then all these small landowners, and even if you have 100, 200, you still acres, you still very well may not be in a position, and probably are not in a position where, depending upon the case and all these different factors, that it makes sense for you to proceed against the company as an individual. So companies do not want you to group together. They don't want you to group together as a class of landowners who are fighting them simultaneously. Because if you win, that's going to have a serious negative effect for the company. If they can divide and conquer you, separate everybody, then if they lose one case, then they win another, they lose one, they win another. Also, because you're divided, now you have to bring a case on your own, and you may never and probably will never do that because it's going to be too challenging financially and otherwise to challenge the company on these issues. So, here's what happens. They put in these mandatory arbitration provisions. Arbitration rulings do not set precedent for future cases. So you could go into arbitration and win a case about a company taking deductions or not, and you can go in and win. And then your neighbor can say, aha, my neighbor won this. I'm going to take that arbitration award and I'm going to sue the company too. Well, that arbitration award that your neighbor got cannot be used in your case. It is not precedential. You can't use it and say, aha, this happened here. New arbitrator, judge, jury, whatever, you have to follow that. That is not the case. You're listening to All Things Marcellus with me, Attorney Doug Clark of the Clark Law Firm. So you may be saying, yeah, that Doug Clark guy, he's so pro-land owner, which I am, so pro-oil and gas right owner, which I am. He's the guy who never has and never will represent gas or pipeline companies. So maybe he's, offering his perspective, and certainly the company may have a different perspective. Well, let me give you a provision here. So this provision entitled Dispute Resolution, now it's long, so I'm going to pick, but I'm going to give you the real language of this provision, says resolution of disputes. If any dispute arises in relation to this lease and it cannot be resolved through direct negotiations. So you say, hey, company, you're taking deductions. You shouldn't do that. And they say, no, we should. Well, you can't resolve that in direct negotiations. It's over. Either party shall, which is a mandatory return or term for a requirement, either party shall initiate mediation by giving notice to the other. Mediation just means you go sit down with the mediator and make your case, and that mediator will make a recommendation, a non-binding recommendation, meaning it means nothing. So you sit down with the mediator and you say, hey, mediator, company shouldn't take deductions. Company says, yes, we should. Mediator says, in a perfect world, hey, you know what, landowner, I agree, this company shouldn't take deductions. Company says, well, you have no authority over me whatsoever, so I'm going to continue to take deductions. Mediator, I don't agree with you. And there's nothing you can do about that as a landowner. So then it goes on. Here's back to the agreement. If a dispute is not resolved by mediation, either party then can initiate binding arbitration by giving notice to the other party. So now, whatever an arbitrator decides, that's going to be binding. But let's just say you have 25 acres and in 1 year the deductions were $10,000. So you say, okay, well, I want to sue the company because they're taking these deductions, but I've only lost, which is a lot of money, $10,000. Well, each year, let's pretend you lose $10,000. In 10 years, that's $100,000. Do you wait 10 years to bring a claim, or do you go and bring a claim right away? Well, or do you say also, hey, look, there's a lot of people. I know my neighbors. I know there's a lot of people that are in the same situation that I'm in and have this same language. So, boy, I think it would be nice if I could group together with them and we could sue the company at once, and so we can share expenses, share all these different costs and resources, and we can go after the company as a group, as a class, and have this strength. You're listening to All Things Marcellus with me, Attorney Doug Clark of the Clark Law Firm. Make sure you join me each and every week at this time on this station. So let's go back to the document again. Real quick. You're losing $10,000 a year in deductions that you don't think should be taken. This lease says first you have to go to mediation. Then you go to binding arbitration. Well, mediation isn't free. You got to pay the mediator. You got to pay your attorney. You got to pay for documents, travel, whatever else you have to do. It's not going to be cheap. That's going to be expensive. So if you're losing $10,000 a year, that mediation may cost you $10,000 or more just to mediate. So you're not going to probably do that. Also, remember that mediation is non-binding. So you have to go through mediation first. That's your first hurdle. The mediator can agree with you totally. The company can ignore it. Next step, you go to binding arbitration. You say, you know what, though? I really want to group up with these other people because the company, I feel, is cheating everybody like they're cheating me, thousands of people. So you say, I want to bring a case as a class action. Well, remember, this says that if you have a dispute, you have to go to mediation, then you have to go to arbitration. Now, here's the next part. So this is either party after mediation must initiate binding arbitration by giving notice to the other party. All claims brought, please pay attention because this is important. All claims brought by a party is in an individual capacity and not as a plaintiff or class member in any purported class or representative proceeding. And there shall be no authority for any disputes to be arbitrated on a class action basis. Why? Because my opinion, it now gives a company the license to, some people say steal, some people say take deductions that maybe they shouldn't take, or there's a gray area, and now they have the protection that they cannot be sued under this lease as a class action. So if you're losing $10,000 a year, which is a ton of money, you're losing that in deductions, you under this lease can't sue as a class. If 20,000 of you have the same scenario, you can't group together and sue the company. You can't sue as a class. You have to go individually through arbitration. And I'll tell you, from a practical standpoint, I don't care if you're losing $20,000 a year. Many, many people are never going to go and bring that type of claim because of the price and the expense to bring these claims. And if you do and you win, that arbitration ruling in your favor can't be used in other arbitration proceedings to say, haha, look, we won here, my neighbor won, so I should win on this same exact issue. Court decisions are generally precedential, meaning have value as you go forward. Companies don't want that. They don't want that. They want to have mixed up rulings. Oh, well, they want to win everything, but if they can't win everything, they want to have rulings that don't carry weight. So in case they lose, each case is a new shot at it. Each case is a new shot at it. So this isn't accidental, and this is in the form of their lease. You're listening to All Things Marcellus with me, Attorney Doug Clark of the Clark Law Firm. As usual, depending upon your perspective, it gets worse or it gets better. If you're a landowner, it gets worse. If you're the company, the document that you wrote, good job, because it even gets better for you. Goes on. Here's another provision, again, under dispute resolution in this lease. It says that once you get into this arbitration, you have to follow the conflict prevention and resolution rules. Probably have no idea what those are. Well, you should if you're going to sign a document. But it goes on and says that in this arbitration process, it even sets some rules. It says that the parties shall submit true copies of all documents considered relevant with their respective statement of claim or defense or any counterclaim or reply. Now, this next sentence, go back to the websites and listen to this next sentence again, or write it down. I'm going to say it twice. Here's this next sentence. Neither party may compel the other to produce additional documents. The maximum number of witnesses each party may call to give evidence is 3 witnesses of fact and 1 expert witness. You are agreeing that whatever documents they supply to this proceeding that the company deems relevant, you agree that you cannot compel or require that gas company to produce any additional documents. You're limited literally to the documents they elect to provide. Then you're limited to 3 fact witnesses and you're limited to 1 expert witness. If you don't think this is designed to stop you from suing, to deter you from suing, to allow them to take royalty deductions in cases where it's a little bit of a gray area, or maybe we see it as even not very gray. But now this is the format and this is the process of how you can sue them. That, ladies and gentlemen, is a horrific provision, and there's the double whammy. We can set our gas price by selling the gas to ourselves. We can use index pricing, and then you have to go to arbitration, and we'll tell you what you can use, and we'll tell you how many witnesses you have, and we'll set the location. Not good. All right, I'm up against it. You're listening to All Things Marcellus with me, Attorney Doug Clark of the Clark Law Firm. Remember, stop signing bad agreements. Please stop signing bad agreements. And the landman works for the company, not you, the landowner. Have a great, great week, everyone. See you next week.